we're joined by Mr. George Eke. He's a legal practitioner. Thank you for coming this morning.
Good morning.
Well, they all seem to be happening quick and fast, such that before you could digest one, another one's happened. And so some are already saying, just like they describe certain seasons in sports, Judiciary, it looks like they've got a season going on here. But how would you, looking at some of these court judgments, just happening real quick and fast and not even being able to digest them real fast, and some of them also surprising to a lot of people, is that beginning to say that is the judiciary actually rising to perhaps fill in that gap of doubt that had existed previously?
Well, it's just because of the preponderance of cases that they are deciding now. But that is not to say, however, that it is not part of the dividends of democracy, because if you look at it from that angle, you notice that the judiciary appears to be firing on all cylinders, and that is why they are churning out a number of all these cases. Quite a number of them people have, commended them. A number of them, people are thinking that they have not gotten them quite right, and like most cases, people have interest. If you succeed, you will say the judiciary is there for the common man. When you don't succeed, it is like it's a travesty of justice. And but again, it is left for us lawyers to look at the merit of the case, as it were, and when you look at the ratio decidendi of most of those cases, you now begin to find out why those decisions are taken.
Okay, well, let's get that reaction to you now. Remember, they were acquitted of that 38 billion naira loan taken from banks by the House of Representatives during their tenure. Here's a response.
It started with a dramatic arrest at the Asokoro Abuja home of the former Speaker on Sunday, the 5th of June 2011. It was a few days after his last sitting in the House, and he was wanted by the EFCC over alleged financial impropriety committed during his time in office. 3 days later, Honorable Bankole was charged to the Federal High Court, Abuja, where a 17-count charge was preferred against him. The commissioner accused him of contract fixing worth millions of naira and also inflation of the cost of items bought by the House, such as television sets and digital copiers, which it described as an act of fraud and an offence contrary to sections 58 subsections 4A of the Public Procurement Act of 2007. To all these offences, Honorable Bankole pleaded not guilty, and after 8 nights in the custody of the EFCC, he was granted bail in the sum of 5 million naira, but subsequently rearrested immediately he stepped out of the court. It turned out that the EFCC had arrested his deputy, Honorable Usman Nafada, the day before, and both men were promptly jointly charged before another Abuja High Court on the 14th of June last year. Both men pleaded not guilty to charges of obtaining loans of about 40 billion naira from UBA and First Bank of Nigeria, and using same to pay the House members' jumbo allowances different from what the Revenue Mobilization Allocation and Fiscal Commission approved for them. They eventually got bail 2 days after they made the request for it, in the sum of 50 million naira with 2 shorties who must be permanent secretaries in the Federal Civil Service, after which the former Speaker challenged the competency of the charges and the right of the prosecutor, Mr. Festus Keyamo, to prosecute him without the fears of the Attorney General of the Federation, in the 2 courts for which he is facing charges. Justice Donatus Okorua, who is handling the first case in which the Speaker is facing charges alone, regarded the allegations of bias against Mr. Keyamo as irrelevant, but held that there is sufficient evidence linking the former Speaker to the alleged offences. He has fixed trial in the matter for the 7th of February 2012. However, reprieve has come the way of the former Speaker and his deputy in the case before Justice Suleiman Belgore, who agreed with them that they have not committed any crime by obtaining a 40 billion naira loan for the payment of an enhanced package and running cost for members of the House of Representatives. What this then means is that for now, former Deputy Speaker Honorable Nafada is free, at least until and if the EFCC appeals the decision. Honorable Bankole, however, still has a pending case to contend with. Shola Shoyele, Channels Television News.
Pleased, and as is very, very clear, we had always said that we're not involved or interested in trial by media, trial in the newspapers, trial on the television. We're interested in a trial in court. You have all seen, you listened to a judgment that detailed everything and showed that the accused persons had absolutely no case to answer, and that these charges had no basis in fact or in law. And we're very happy that the court has found that.
Remember that this is just one charge against the Speaker. This one relates to the taking of loans and the increment of their running costs. The other one regarding the other charge pending at the Federal High Court regarding the misuse of capital votes. That charge is still pending, and we are going to begin trial sometime in February or March or so. So that charge is still pending. This is just one charge. But let me summarize what the judge said, with which we disagree. One, that for them to have sat down, the legislature, to increase their running costs from 27 million naira to 42 million naira per quarter is a moral wrong. That is, they were wrong to have done that, that they were insensitive to have done that, but that it does not amount to a crime, because as legislatures, they are a third arm of government, that they have a right to do what they like with their funds. We disagree with that. The second reason he gave is that constitutionally, the Speaker and the Deputy Speaker, they have no control over the funds of the House, over the accounts of the House, that they have no control. In other words, the functions assigned to them in the Constitution do not include the operating of the accounts of the House. We disagree with that, because the evidence presented by everybody said that without their approval, they cannot operate the accounts of the House. They were very clear. So even if somebody is not constitutionally given powers to do something, and he usurps the power to do it, he has to account for the usurpation of that power. So these are the points we totally disagree with.
Well, there you have it. Some words stuck out there. No trial by media, and the pages of papers, the television, and then the other cancer size. Well, yes, the judge ruled that morally wrong, not a crime. How do you read all of this?
Well, you see, that is how law operates, unfortunately. We can always say there is a difference in law between what is morally reprehensible and what is an offense. Offense, for you to ground an offense in crime, it has to be a written law that you have violated. Yes, a number of Nigerians are probably unhappy that they escaped, so to speak, justice, because the truth is also different from the fact. In law, the law looks for facts, not the truth. If for any reason the truth becomes the fact, it is okay, but the law operates with the fact. Look at this example. If you and I were in a bus and I stole your purse, and for some reason you started shouting that your purse had been stolen, of course I drop it into the open pocket of Sulai, and everybody says, let's come down from this bus, because whoever stole this purse is still in this bus. And they search everybody and find out that Sulai has that purse, even without he knowing that the purse has been dropped into. Sulai will go to jail, because the fact is that he has the purse that was complained as stolen. But the truth is that I stole it, except there is any witness that can make a nexus between when I dropped it in Sulai's, otherwise Sulai simply goes to court, goes to jail. So law looks for the fact, not the truth. The truth of the matter is that they probably may have misappropriated money. That may well be the truth of the matter. But you see, in criminal law, unlike civil proceeding, where everything is, the proof is on preponderance of evidence. In criminal law, the standard of proof is beyond reasonable doubt. It is higher. So you have to work hard to be able to ground a charge in a criminal offense, as against a civil offense where it is balance of probability or preponderance of evidence. So it is a harder thing. So that is why it is important when you are trying to prefer a charge on a criminal matter, you work very hard and charge under a relevant law. Like I said, the truth of the matter is that they may have appropriated money. But the technicality that is in law is such that the judge just cannot find it.
And again, you say, and lawyers also say that, well, what's in the court of public opinion does not necessarily affect what happens before the judge. They argue based on the facts.
Also, the facts before them, that is it. So that is why a lot of people will be very disappointed about this judgment, but that is how law operates.
Oh dear.
Actually, I was trying to look at, when we talk about the issue. So what's the place of morality in law?
Yeah, morality, by the time morality is codified as law, it becomes operational. I'll give you another example. That is also the difference between a crime and sin. If for any reason I was walking past a swimming pool and a 3-year-old boy was drowning, is about to drown, and I simply look at the child, this child is about to drown, and I walk away. It is a major sin. In short, a Christian mother will say the hottest part of hell is reserved for me. But you see, I am not a lifeguard. I do not owe that child any duty of care, and to that extent, I am not negligent, nor can I be liable for the relation of duty. I simply walk away in the eyes of the law, but in the eyes of the public, I must have committed a very heinous crime by not saving that child. So that is how morality, the relationship between morality and law. Except it is codified, then I can be charged for it. So that is what it's like a lesson that by the time EFCC begins to charge anybody, let them do their homework very well, so that you are charged under a particular law and the proof of evidence, it will be so overwhelming that the person cannot escape it.
Okay, but looking at their point of objection, I mean, you heard Festus Keyamo was there state the things that they do not agree with, and it looks like they might go back to court. Do you think that they will stand a chance the second time?
Well, it depends on what proof of evidence they are going to. In any case, at the appeal level, is unlike the trial court, where you begin to adduce evidence and all of that. They are now looking at the facts of law, whether the lower court erred in dismissing the charge.
Okay.
But again, just the way Chamberlain said, it's been a busy week. Just before you stay on a particular story, that's just the freshest, if you will allow us to use that now from the judiciary. But again, remember what actually has been going on with regards to the 5 states. Specifically, now we want to look at Kogi, even though they will still say Kogi is almost done with and has moved ahead, as well as Bayelsa. But again, people are still trying to read meaning to the initial swearing in of 2 people in charge of the state, that is Kogi, and again, INEC's, should I say, order now, because we have to go back to the Constitution. Where does INEC get the power to say that someone should be sworn in as a governor?
Well, you see, INEC is the umpire, as it were, in our electoral system. And there's hardly any electoral matter you will talk about that will not involve either the opinion, I started with the word opinion, not approval, the opinion of INEC, and to that extent, the opinion of INEC is quite weighty. Look at the scenario. The Supreme Court says these 5 governors in their tenure elongation, the tenure expired in May 29,
yes,
last year, and that for the 8 months they have stayed, it's been an illegal extension, as it were. And the way, I think they didn't make any consequential order. Not I think, I do know that they didn't make any consequential orders. But what flows from that is that a vacuum has existed. And of course, the Solicitor General now ordered that the speakers of the different houses of our assembly be sworn in as acting governors. But I think it was quite a very blanket instruction, in the sense that he didn't take the peculiarity of Kogi into cognizance, even though he has been variously accused of having an interest that is not particularly unbiased, in the politics of his own state, that is Kogi. Because the peculiarity of of Kogi State is that there was a governor-elect, duly elected by a duly certified body, that is a statutory body called INEC, was waiting for the governor, Idris, to serve out his term. The Supreme Court now said that term has become vacant, that position has become vacant. It only appeals to reason. That you don't even need to get into law. It is just logical that this man who has been waiting for next month, or I think his term was going to expire in March or thereabout, either February or March, whatever time it was, that it has become due as of Friday last week. He will simply slip into that position because he was governor waiting. He was a governor-elect.
You know, people have actually gone to court saying, specifically Oyebode Makinde, well, he's seeking a declaration that INEC's order or directive that Wada be sworn in is unconstitutional, null and void, and he said the first defendant's order and directive that third defendant be sworn in when the fourth defendant is discharging same function pursuant to section 1912 of the Constitution is simply unconstitutional.
No, I don't agree with him. Well, I'm not about to preempt the decision of the court, but I can assure you I will come back on this television and tell you that he has failed. Just like I have a way of predicting quite a number of... when I decided very vehemently with the lawyers who were saying that the tenure allegation was in order, and probably were just a few lawyers that were alone in the fact that INEC should continue to proceed to Supreme Court. Indeed, at that point in time, we were variously criticized that INEC didn't even have a local standing. I mean, what saying in a local palace is that what is their own? Did they contest any election? But you would have found out that it was good for our jurisprudence. I mean, it's developing our legal system. But again, I can also predict that is not going to, he's not going to succeed. In the sense that I've also taken time to look at section 191, which is actually the section that he's predicating his argument on.
Yeah.
I don't even think, apart from the fact that we have adapted it to this situation, that section does not take cognizance of this particular circumstance.
How?
It's talking about should there be the date of the governor, the deputy governor will slip in, take his position, and should two of them be removed either by impeachment. In short, it said quite a number of, I think about 5 items, through impeachment, through whatever. It never envisaged the situation where a court will sack the government, as it were, the governor and the deputy governor at the same time. But what we have just done is just to adapt it. Indeed, a number of lawyers are of the opinion that these speakers are in such positions illegally. But you see, the point is that the Constitution cannot say everything, take care of, envisage every circumstance foreseeable in human life. So we have just adapted that to allow the thing. But politically speaking, I have my reservations about speakers taking over. Okay, but talking politics as against law.
All right, but then even talking about
because let me make this point. Because you see, when the speaker takes over the realms of power, they get reckless. The stories we got from the times these 5 speakers. The speakers, not the same people though, but the speakers of these 5. Because at the point in time when these elections were being rerun, the speakers were holding forth for the governors, and they were to say the least reckless.
But isn't there any law
because
to check
they didn't promise you anything? It's not like they have any agenda. They know that they are going to be there for a short while. And knowing the Nigerian politicians the way we are, somebody becomes a governor for 3 months. He's not about to begin to do any water project for you, no education. He has no manifesto. He didn't promise you anything. He's not about to execute anything. He is only just managing your statutory allocation for 3 months. And it is a disaster for us. But indeed, I have always opined that the shorter the periods they hold such position, the better for the country.
Who would you, Chamberlain, who would you recommend fills that gap in the interim?
No, the speaker. The way it is the speaker. That's like I told you, we have adapted that part of the Constitution.
Okay, but you're saying we shouldn't even come to that situation.
No, if we can avoid it, let's avoid it. Because the speakers are not accountable to anybody. It's not like they are coming to ask for a re-election. It's not like they promised you anything during their their campaign. They do not have any manifesto. They are not about to begin to execute any projects. They just hold forth for that length of time.
Okay, well, when this judgment came out, there were those who said there was definitely bound to be lots of litigation. I mean, we've already seen some of them going to court in Kogi, for instance. Do you think that the Supreme Court should have given a consequential order, perhaps to forestall all this?
Yes, it is. That's my opinion, actually. That's I'm uncomfortable with a situation where they make, even though I know that they would have come by originating someone, that is to say, help us interpret this part of the Constitution. What does it say? What does it actually say? But I think in such circumstances, especially with what has happened now, the Supreme Court should go a step further to say 1, 2, 3, 4 orders are in place, so that we are now putting the Supreme Court as an order of courts.
What's the process? Can they do it without an originating summons, or can they just...
Oh no, they can always give consequential orders. The court can always give consequential. It's part of the inherent powers of the court.
Mm-hmm. I also wanted, sorry Marco, I also wanted us to look at INEC, the timetable, the speed with which all of this timetable finally came out. In particular, let's look at the Electoral Act, Section 26 and Section 30. And we look at Section 30, it says the Commission shall not later than 90 days before the day appointed for holding of an election under this Act publish a notice in each state of the Federation and the Capital Territory stating the date of the election, and B, appointing the place at which nomination papers are to be delivered. So, for instance, the very first elections will be in Adamawa State, February 4, and Kogi, Bayelsa will be February 11. So is this what the Electoral Act states?
You see, there's a way people are misunderstanding the circumstances of the order of the Supreme Court. A number of people think that it has voided quite a lot of processes that were in place before they made the order. The answer is no.
It hasn't?
It hasn't, yes.
How?
You know, it doesn't have a retroactive effect. That has to say, I've wiped out what has taken place before we gave this order. The reason is that there were processes for these elections that were in place before the order was given. And these processes were not voided. So if INEC had gone ahead to fix a particular date for the election and had done the necessary electoral processes towards achieving that date and all of that, they are all valid. So that's what INEC is doing. So INEC is not like trying to see there is a new dawn. Let us now begin to give notices, let the parties begin to do primaries, let us begin to give forms and all of that. They are all, indeed what I thought was going to happen is that they probably will get a uniform date to conduct the elections in all the 4 remaining states. It would have been more convenient for them, administratively speaking, logistics-wise and all of that. Because you see, these are also going to have eventual effects on the dates of the elections in the next 4 years. So in other words, it means that these staggered elections will still take this nature in the next 4 years. But if I were them, for purposes of logistics and all of that, they would have just simply, within the period that the court ordered, given a uniform date to conduct elections in the 4 remaining states.
That also said, it took so long, but eventually it came. Of course, so many reactions coming out. Then the timing. Does law look at all of the social circumstances before some of these judgments are eventually even handed down, by the way?
Well, I will talk about subjectivity in law, which a lot of people do not, take cognizance of, but exists behind decisions. That is not to say that the facts are not always, applied or not sought for. Let's talk about the first remark you made about how long it took. I have noticed the number of people talk about the long hand that the judges use in recording matters and all of that as being responsible for this drag or this delay in the dispensation of justice. Yes, it is a major one, but it's in this particular case. I happen to have followed it, from the time, Al-Mustafa was charged. I just had an interest, especially because it became a soap opera. Al-Mustafa and his lawyers almost challenged literally every ruling, every decision of the court on everything, both admissibility of evidence, relevance of evidence, in short, literally everything. At a particular point in time, we thought that it was being, they were doing that because they were looking for some kind of political reprieve. Maybe somewhere along the line somebody says, or maybe Attorney General applies a nolle prosequi, we're no longer interested in this case and all of that. We thought there was a political dimension to it. But surely and slowly, it kept going. But the delay was more from the defense. They have had about 5 judges handle this matter. Think about 5 judges. Some of them were accused of having compromised. Some of them were accused of bias and all of that. And they kept changing them. And that each time the matter comes to a different judge, the matter starts de novo. That's part of why I'm not going to tell you this. But you see, I don't think that his lawyers also advised him properly with regard to how he presented himself.
Why is that?
Here was a person who was charged with one of the highest crimes in our criminal code, murder. And he made a political showmanship out of it. You would have seen how he comes to court. The way he's almost like a his trial reminds me of the trial, the last day of Bode George's trial, where he came to court with starched brocade, acknowledging chairs like the politician he was. Drummers were outside the court, people with coolers of rice and all of that. He was coming to court. You know what the court is? In that 4-corner room, you can lose your life and your livelihood. As small as that courtroom is, with a croaking fan and maybe dusty files and all of that, you can lose your life there. That's the seriousness of a court. He simply comes acknowledging chairs and all of that. Indeed, in the case of Bode George, they were still drumming outside when somebody came and informed them that the man has gone to jail. That's exactly what I saw because you see, the judge is bothered about the behavior and the conduct of the parties. Indeed, in quite a number of times in criminal matters, even in civil matters, the last thing they say, the conduct of the parties. The conduct of the parties is important. And that is why every time a case comes to a new judge, it's not as he starts de novo. Once he starts de novo, that's starting afresh. It's not as if the facts have been destroyed by the earlier judge.
From that.
He wants to look at the demeanor of the people giving him evidence, the testimony that he's giving. He wants to watch them to be able to make
not just the evidence alone.
No, just your conduct. That is to be able to make up his mind. That is why I told you about subjectivity. And in any case, if you read the law report, you keep hearing, I believe the PW1. I believe is subjective. Is that not so? I've been convinced. I looked at the person. So that's the subjectivity in it. They did not apply that. Indeed, it is such that if you have a matter and you know that the judge is probably a born-again Christian, that your client, who is a defendant or probably an accused in some states, find a chaplet and with a big cross and put on him. And while you are taking his evidence, his examination in chief, be calling him Christian. What do you think about this? Christian, tell the court that is, and once in a while you should lace it with as in Jesus' name, or by the grace of God and all of that. Those are things that will build piety out of him. He must be pious.
Sometimes they count. But again, remember,
look at, have you painted this picture?
Sorry, Mr. Eke, let me bring this so that you can also paint it for us now. They say that some of these were not done properly, because some are saying, yesterday we had one of our guests here, he did say, well, it cannot properly fit into beyond all reasonable doubt, the way lawyers will couch it, because for the fact that some of the witnesses who said they were sent to kill the late Kudirat came back to tell that same court that they were coerced to lie against the accused, so therefore the doubt should have been resolved in the favor of the convict.
No, I don't think so. In any case, the person will be wrong if we are encouraged not to say beyond all reasonable doubt. It is beyond reasonable doubt, because there is no way you can prove a case beyond all reasonable doubt. It is beyond reasonable doubt, or you talk about any shadow of doubt. Okay, but going beyond that, in criminal matters, it behoves and it hovers around admissibility and relevance of evidence. What weight you are going to attach to any evidence, and how much of it you can admit. If that's the opinion of the lawyer regarding certain pieces of evidence that were admitted and that should have been resolved in favor of the accused or the defendant, which is a normal principle that once there is any doubt, it must be resolved in favor of the accused person. But I don't think that is exactly what happened in this matter. There have been a preponderance of evidence, quite overwhelming, according to the judge, quite overwhelming. And so part of why I started this analysis by talking about maybe the behavior of the defendant is that it formed part of what was said, that he was full of intimidation, and I'm sure that's part of it, full of intimidation, arrogance, and then had a lot of afterthought. These are also part of what also formed the opinion of the judge. I'm not saying that was the major thing, but I'm saying it may have also added to that. That is not to say, however, that the facts of the matter, the piece of evidence that were adduced, were not properly taken cognizance of. But in any case, they have the defense counsel has said that we're going to go to we're going to go on appeal, and in any case, once you go on appeal in a death sentence, it serves as a stay of execution on its own. Okay. So, like the case of Bello and AG of Oyo State, where somebody went on appeal and was executed even before the appeal, was decided. So the courts are avoiding such circumstances. The moment they go on appeal, it will. The appeal court will look at these reservations. Of course, the grounds of appeal will be looked at, and the issues formulated there.